All right, let's see if we're live. Do we get... Good, good. I think we have a good connection here. Hello, everyone. I'm Leonard French, your favorite Ascension, Wisconsin case. This was the case where the judge had granted a temporary restraining order requiring the 7 employees that left ThedaCare to join Ascension. Well, they had to go back. 2 of them had to go back to ThedaCare temporarily until ThedaCare could hire more people, or maybe ThedaCare, well, Ascension would have to cease hiring the individuals until ThedaCare hired adequate staff. And if that sounds a little outrageous, that it is. It's really outrageous, and that's why this has blown up on the internet, and why everyone's covering it, why everyone's talking about it. Well, what has now happened is after that Friday temporary restraining order, there was a full hearing today, Monday, and now after the hearing, Judge McGinnis has dismissed the temporary injunction as reported by Madeline Heim from, I think, USA Today. She says all the employees will be able to report to work at Ascension starting tomorrow, and she's writing a story about it. Well, Kurt Mueller and I just talked about the opposition brief that Ascension's attorney David Muth filed in opposition to Friday's temporary restraining order. And the short version of the Friday restraining order, which sounds really unjust, and I wasn't really defending that it's unjust, but I was defending it on the grounds that it's pretty normal for courts to implement a temporary order and then immediately hold a full hearing to either void that order or alter that order. So having the complaint filed on Thursday and then the restraining order on Friday and then a full hearing on Monday, that's normal. As much injustice as it sounds like, I'm not blaming the judge because that's pretty normal legal procedure. But in the meantime, the Ascension, the opposition, the defendant was able to file an opposition brief. And now that we know that the temporary restraining order has been dismissed or voided or vacated, now we know that the judge agreed with the arguments that Ascension's attorney made. Those arguments are pretty epic arguments, and they pretty much reflect every criticism of this situation that has been put out, has been imagined, every premise that has been forwarded in argument against this TRO. So without further ado, I'm going to read through this with you, and I think you'll really enjoy this. This is Ascension Northeast Wisconsin's brief in opposition to ThedaCare's motion for the temporary restraining order. Introduction. Your failure to prepare is not my personal emergency. This wry observation, a favorite of parents, teachers, coaches, and perhaps a few judges, concisely captures the core concept of personal responsibility most of us learned in our childhood. Don't blame others for your own mistakes. Evidently, that concept is lost on ThedaCare. With this frantic, last-minute lawsuit, ThedaCare attempts to convert its own poor management into a disruptive personal emergency for everyone, anyone but itself. Ascension, this court, and worst of all, 7 essential healthcare workers who until Friday believed they were starting new jobs on Monday morning. The evidence already emerging confirms that ThedaCare's emergency is entirely of its own making. This is true in the ordinary sense of that phrase. Ascension has not poached any employees. They left ThedaCare unprompted, and ThedaCare has only itself to blame for failing to maintain a competitive working environment for its medical staff, opting instead to underpay its essential workers and even refusing to make a matching offer to those employees when given ample opportunity to do so. ThedaCare has known of this departure for weeks. The employees announced their employment offers from Ascension on December 21st, 5 weeks ago, and their resignations on December 29th, and ThedaCare rejected multiple alternatives for retaining or replacing them, some of which are still available to ThedaCare today, opting instead to waste its money and everyone's time on this frivolous lawsuit. But this emergency is also of ThedaCare's making in a second and much more troubling sense. ThedaCare has invented the emergency, ostensibly justifying this lawsuit. As the facts will show, allowing 7 healthcare workers to leave ThedaCare for the hospital of their choosing, Ascension's St. Elizabeth Hospital, not even 7 miles away, will not plunge the Fox Valley into a critical care crisis, as ThedaCare claims. St. Elizabeth already offers the medical services at issue, just without the fancy designation ThedaCare appears to view as a better use of funds than paying its workers. And Green Bay is and will remain available as a backup option. No need for diversion to Milwaukee or Madison. In short, this emergency is entirely of ThedaCare's making because ThedaCare is making it up. Now let me interject here for a second. I'm hearing someone knocking at my door here. Is there someone knocking at my door? Hi. There is. There is someone knocking at my door. Say hello to Lucy, who would really like to get down right now. In that sense, it seems ThedaCare missed a second lesson of childhood, the story of the boy who cried wolf. Apparently, ThedaCare hoped that if it moved quickly enough and prophesied sufficiently dire consequences, it could get an injunction or perhaps just force a settlement before anyone looked too closely at the merits. Its after-hours court filings and its preemptive media press release appear calculated to do just that. But that strategy is now backfiring, and then some, as the truth comes to light. That childhood story didn't end well for the boy, and this lawsuit shouldn't end well for ThedaCare. Inventing an emergency and then blaming it on others is shameful behavior under any circumstances. To take advantage of pandemic conditions on top of it is disgraceful. ThedaCare has no legal leg to stand on, and the facts clearly support Ascension. The court should deny the preliminary injunction, vacate the TRO, and leave ThedaCare on its own to fix the mess it made. Now, you can go back to Kurt Mueller's live stream where we went over ThedaCare's brief, but the short version is that ThedaCare, they had a long, rambling brief for the TRO, but they didn't include really any legal argument whatsoever. They didn't include any hard facts pointing to actual injury that they're going to suffer. Instead, they spent the entirety of the thing speculating about how maybe some patients wouldn't get the care that they need, and if somebody doesn't get care, maybe somebody could die. And there really wasn't a lot, there wasn't really anything more than one legal citation to the standard for an injunction. There were no citations to any legal precedent that shows ThedaCare should get this temporary restraining order on these facts. Pay attention to how well written this brief is compared to my characterization of that. Reading ThedaCare's court filings, one would think the Fox Valley will be plunged back into the dark ages of medicine if 4 radiology technologists and 3 nurses, the invasive radiology team, which invasive radiology is kind of a funny term for it because what it really is it's an anti-invasive surgery radiology team. They do the x-rays and the MRIs and the CT scans with accuracy to then provide to surgical professionals who can do smaller amounts of surgery or more targeted surgery without having to do more invasive surgery. So it's kind of a funny misnomer. If those technologists and nurses are permitted to leave ThedaCare to work for Ascension, as ThedaCare's entire lawsuit is premised on that professed emergency, Ascension will begin by explaining why that premise is simply false. The IRC team leaving ThedaCare's facility in Neenah will be going to Ascension's St. Elizabeth Hospital in Neenah, fewer than 7 miles away. St. Elizabeth is a level 3 trauma center, meaning it can assess, resuscitate, stabilize patients on site, as well as perform emergency surgery if necessary. The IRC team currently performs this role for ThedaCare and will serve in exactly the same role at St. Elizabeth. This should come as no surprise, as the care will be provided by essentially the same team. In addition, no one on the IRC team is a doctor. Both ThedaCare and Ascension use the same group of radiology providers, which is Radiology Associates of the Fox Valley. In short, the same doctors, the same radiology technologists, the same nurses at a different location. The only relevant difference between a level 2 and a level 3 trauma center is what happens after a trauma patient is assessed, resuscitated, stabilized, including completion of any emergency surgery. If, at that point, a level 3 trauma center cannot provide definitive surgical and intensive trauma care for the patient, they're diverted to the next available level 2 trauma center. Even if ThedaCare were to lose its level 2 certification, a prospect nowhere near as imminent as ThedaCare claims, Green Bay has 2 level 2 trauma centers a 20-minute ambulance ride or 5-minute helicopter flight away. Aurora, Baycare, and Belen. So when ThedaCare paints a nightmarish picture of acute trauma victims clinging to life as they struggle to reach Madison or Milwaukee, ThedaCare is crying wolf. Based on just 2 facts on the record, 1, the IRC team left ThedaCare at the same time for the same new employer, and 2, some of the IRC team communicated with each other about leaving, ThedaCare insinuates that Ascension designed and executed a coordinated poaching intended to cripple ThedaCare's radiology function overnight. The reality is much less dramatic and reveals only ThedaCare's own managerial ineptitude. Ascension posted for these positions publicly. It was seeking to fill a large number of positions, due in part to the same staffing shortages affecting the entire healthcare industry during the pandemic. Ascension did not target or reach out to anyone at ThedaCare specifically. Mr. Scott Fisher, Ascension's hiring RN, will testify to this, as will every member of the IRC team. When Ascension posted the positions, one radiology technologist, Ms. Kaylee Young, applied via the normal process. She was granted an interview, Ascension found her to be qualified, and made her an offer with better compensation and benefits than she was receiving at ThedaCare, as well as a better working experience and work-life balance. Sounds good to me. Can I go? Ms. Young, who had been working for ThedaCare since graduating from tech school in 2011, so over 10 years, accepted the offer. She then informed her fellow radiology technologists. The IRC team is a very close-knit group and have become increasingly dissatisfied with ThedaCare's management over the past several years. Previously, the team received a notice that ThedaCare management had completed a compensation survey and discovered that the team had been underpaid for years. ThedaCare's answer to this was to give the team a small raise, but no back compensation. Then in March of 2021, a year into the pandemic, ThedaCare fired 2 nurses on the IRC team, citing a trivial policy violation. These 2 nurses were viewed as excellent workers, and their loss was a negative turning point for many on the IRC team. The team's reaction was that ThedaCare did not care about how these losses would impact the remaining team members' workload or patient care. In fact, it was this decision by ThedaCare that caused Ms. Young to begin looking for other employment that very same month. When Ms. Young informed her fellow radiology technologists of her new opportunity with Ascension, where positions remained unfilled, what happened next is no surprise. Each of the remaining 3 radiology technologists likewise applied to Ascension. Each was interviewed in turn, found to be qualified, and offered a job. Mr. Paul Winter, Mr. Timothy Breister, and Michael Preissner, all the other radiology technologists on the IRC team, will corroborate these facts. They each applied after hearing from Ms. Young that Ascension had openings and the pay was higher. Ascension offered each a wage increase and signing bonus. After years of working for ThedaCare at below market wages, each accepted the offer. The nurses on the IRC team were hired similarly. Andrew and Amber Kaler, a husband and wife RN duo on the IRC team, had been trying to get an Ascension nurse to join them at ThedaCare when the Kalers learned of the open positions at Ascension. Again, there was no recruiting by Aurora or Ascension. The Kalers each applied in the ordinary course. Like the radiology technologists, Ascension gave them a better offer that included higher compensation and signing bonuses. Like the radiology technologists, the Kalers were readily accepted. To be clear, both the signing bonus and the compensation offered to the IRC team are part of Ascension's standard market compensation in this environment and were in line with compensation for Ascension's existing employees. The Kalers will also testify that no one at Ascension asked about hiring other team members, and they had no idea that the radiology technologists on their team had applied to or received offers from Ascension. Samantha Baltus, the remaining IRT team member involved, applied for an open position once she learned her friends and colleagues on the IRC team planned to leave for Ascension. Other witnesses will corroborate this testimony. Each member of the team independently sought out Ascension after hearing of the better opportunities available to them there. Ascension didn't poach or even recruit the IRC team as a whole or individually because it didn't need to. ThedaCare made the decision to leave independently attractive to each. The sentence is a little bit weird. ThedaCare made the decision to leave independently attractive to each member of the team. I think there's a missing word in there. Basically, it's ThedaCare's fault. Start dates for Ascension's new employees were agreed upon in the ordinary course. Despite their dissatisfaction with ThedaCare, the IRC team members are professionals and they wished to give notice. Ascension did not ask the IRC team members when they would resign and made no effort to coordinate their departure en masse. This was left up entirely to the individual employees. Indeed, Mr. Fisher will testify that he had no idea how big the IRC team was and did not know he was hiring away all of ThedaCare Nina's neurointerventional trained radiology technologists until this lawsuit was filed. By December 21st, the 4 radiology technologists each had received offers to work for Ascension and decided to give ThedaCare the opportunity to retain them. That day, they provided the details of their offers to ThedaCare management and requested a counteroffer. They received no response until December 28, when they were told by Interim Director of Cardiovascular Service Line, Ron Shoemaker, that ThedaCare would not be making any counteroffer. As he put it, the short-term expense of retaining the radiology technologists was not worth the long-term expense, because if ThedaCare paid to keep these employees, it would have to offer raises to everyone. Mr. Shoemaker was clear that this message came from senior management at ThedaCare, whom he had apprised of the problem posed by all 4 technologists' potential resignation. Mr. Shoemaker told the technologists that any coverage issues were not their concern, that he had raised the issue with senior management, and he had to trust that management had a plan in light of their decision to not retain the technologists. Mr. Shoemaker also candidly told them that if he was their grandparent, he would tell them that it was a good offer and they have to do what was right for them. The 4 technologists met directly after this meeting and in light of the response from ThedaCare leadership, accepted Ascension's offers. Then they submitted their formal resignations the following day. Their group's resignation, en masse as ThedaCare would have it, was not the result of some subterfuge by Ascension, but rather the near-inevitable result of ThedaCare telling its employees that they were not valuable enough to retain. By contrast, the Kalers did not bring Ascension's offer back to ThedaCare. They are nurses, and in their view, ThedaCare treated nurses as fungible. In addition, ThedaCare has a very well-known reputation for not countering, perhaps for the reasons stated to the radiology technologists on December 28th. Once they had learned of the decision by their technologist teammates, the ThedaCares provided their notice on December 29th, effective January 14th. Ms. Baltus provided notice on January 7th, effective January 21st, after a confounding period of silence from ThedaCare leaders on how they intended to address the workload going forward. True to its word, at least in this, ThedaCare did not attempt to negotiate with anyone on the IRC team until just days before their final day of employment with ThedaCare. Even then, although ThedaCare fails to explain why it could not reach an agreement with the IRC team, the reason is obvious. ThedaCare made only a half-hearted attempt to retain the departing team members. Also on January 14th, the IRC team members were locked out of their ThedaCare email and other internal systems. ThedaCare refused to accept their resignations and changed their status to PRN Associate, an on-call designation, without their consent. For the most part, none of the 7 have worked since January 14th either. By the way, this is what we would call constructive termination. Ms. Young provided on-call coverage on January 19th and 20th, but there were no calls. Andrew Kaler took one shift on January 20th, the day this lawsuit was filed, as a courtesy, but will not be doing that again. Ms. Baltus' resignation was effective January 21st, and that was her last shift worked. And Ms. Young offered to provide coverage this weekend, but ThedaCare told her she was not needed. She will not be repeating that offer either. Indeed, while the departing 7 showed varying degrees of willingness to assist ThedaCare through the transition before ThedaCare filed this suit, this evaporated the moment ThedaCare attempted to use the power of the courts to force them to return to their old jobs. So if one thing is clear, it is that none of the 7 will be returning to ThedaCare, period. The sky has not fallen since January 14th, nor will it. As noted, the team's last official day of work was January 14th. In the 10 days since, has trauma care in the Fox Valley gone off the rails? Not in the least. As of this filing, ThedaCare has not diverted a single trauma care patient from the Neenah facility, even to Green Bay. To the contrary, as recently as January 20th, ThedaCare's stroke coordinator informed Ascension's stroke coordinator that it did not intend to divert patients elsewhere. Perhaps this is because, as Ms. Detterman avers, ThedaCare has 180 points of care, including 7 hospitals, and has the ability to shift resources from elsewhere. ThedaCare's filings are conspicuously silent on this point. But even if ThedaCare's network lacks the internal resources to cover the IRC team's departure, outside traveling help should be available. Referred to in the industry as agency, this resource is very expensive, but is worth the expense to maintain quality of care for ThedaCare's patients, or what ThedaCare seems more interested in, its Level 2 Trauma Center certification. ThedaCare doesn't say. What is clear that, despite being on notice of the IRC team's potential departure since December 21st, ThedaCare waited until January 18th to reach out to Ascension and didn't speak with leadership until January 19th. For a hospital truly scrambling to provide patient care, ThedaCare's fully prepared lawsuit, emergency injunction motion, and media statement came extremely soon thereafter. On to the legal standards. Courts may grant injunctive relief only when the moving party, ThedaCare, shows that it is likely to suffer irreparable harm without the injunction, that there's no other adequate remedy at law, that a temporary injunction is necessary to preserve the status quo, which was my argument for why the judge implemented some form of TRO on Friday and then immediately held a hearing thereafter. And 4, that ThedaCare reasonably has a reasonable probability of success on the merits, something that I'm not sure that they ever had. But that's why the full hearing was held today and not, weeks later. And here's something that you don't see in the ThedaCare brief is you start to see full legal citations. Yes, there's 1 or 2 in the ThedaCare brief, but it's really only a couple. It's not continuous citations to both facts and law. As they say, if the facts are on your side, you pound the facts. If the law is on your side, you pound the law. If neither the law or the facts are on your side, you pound the table, which I think is what ThedaCare was doing. Courts also evaluate whether an injunction would disserve the public interest. Generally, injunctive relief is addressed to the sound discretion of the trial court. Competing interests must be reconciled, and the plaintiff must satisfy the trial court that the balance of the equities favors issuing the injunction. The equities are the fairness factors. So we don't have a legal or lawful argument, we have a fairness argument. This burden reflects that injunctions are not to be issued lightly, but only to restrain an act that is clearly contrary to equity or fairness and good conscience. Injunctions, whether temporary or permanent, are not to be issued lightly. The cause must be substantial. Further, a temporary restraining order is an extraordinary and drastic remedy, one that should not be granted unless the movement, by a clear showing, carries the burden of persuasion. A preliminary injunction is an extraordinary remedy, never awarded as of right. So first they attack on irreparable harm and public interest. When it ought to be focusing on the consequences of its own mismanagement, ThedaCare demands that this court bail it out, peddling a hyperbolic tale of a crumbling healthcare system and threats of dead patients. ThedaCare has clearly lied to, or at the very least, misled the court about this purported emergency. As usual, actions speak louder than words. Despite refusing to accept the IRC team's resignations and designating them as PRN associates so that it could still put them on the schedule, ThedaCare shut them out of the system, including by turning off access to their email accounts and, with minor exceptions, failed to schedule them since January 14th. Clearly, despite not having these employees on staff for the past 10 days, ThedaCare has been able to cover the shifts. Indeed, at the January 21st hearing, ThedaCare's counsel was unable to identify how many patients may have been negatively impacted, and the answer appears to be none. ThedaCare has not diverted a single patient since January 14th, and has told Ascension it has no intention of doing so. At the same time, Ascension is more than capable of serving the public by stabilizing trauma patients with the same or higher levels of care as ThedaCare, especially now that it has the very same team now working for Ascension. Thereafter, stabilized patients can be moved to a higher level trauma facility if necessary. There are 2 level 2 facilities in Green Bay, a mere 20 minutes away by ambulance and 5 minutes by helicopter. Ascension also effectively provides all the same stroke services as ThedaCare. ThedaCare has not and cannot provide evidence that these present options for care will negatively impact patient outcomes. Put simply, there will be no harm to the public interest if an injunction does not issue. To the contrary, because the IRC team members have no intention to return to ThedaCare and the court cannot compel them to do so, an injunction would only prevent them from providing critical care at all. Moreover, ThedaCare alone is responsible for its reputation and the potential loss of its Level 2 trauma verification and its comprehensive stroke center certification. There is no basis, legal, factual, or otherwise, for ThedaCare's apparent belief that other healthcare facilities have a duty to monitor ThedaCare's accreditation status and avoid hiring decisions that could jeopardize that status, and then be subjected to lawsuits if ThedaCare's employees wish to leave anyway. Ultimately, while ThedaCare touts its significant investment in developing its trauma care program, it failed to invest in its most important asset, its own employees. Even as it made more money as a result of its certifications, ThedaCare failed to adequately compensate its caregivers. Had it done so, perhaps it would not have lost them to another facility. Having lost them now, ThedaCare can pull resources from other locations or from outside agencies, just like any other healthcare system. It could hire traveling staff through an outside agency. ThedaCare is simply refusing to spend what it costs, continuing the pattern that led it here in the first place. Instead, it has spent its time and resources planning its legal strategy and filing this lawsuit. From start to finish, the alleged harm, if any, was caused by ThedaCare's own actions and inaction. ThedaCare will not succeed on the merits. The sole count in ThedaCare's complaint is that Ascension has tortiously interfered or wrongfully interfered with its prospective contractual relationships with at-will employees. And when we looked at that brief, there was no contract that was attached. There was no third party's contract that Ascension had induced the employees to breach by leaving. Normally, when you have a tortious interference with a contract case, you have to provide the contract. There was and is no contract that we could find or contract that was attached or sent by ThedaCare, which is unbelievable. To succeed on a tortious interference claim, the plaintiff must establish 5 elements. 1, the plaintiff had an actual or prospective contractual relationship with a third party. 2, the defendant, Ascension here, interfered with that relationship, that the interference was intentional, that there was a causal connection between Ascension's interference and ThedaCare's damages, and 5, that the defendant was not justified or privileged to interfere. At trial, Ascension will bear the burden to show that its acts were privileged or justified. Assuming, for instant purposes, that ThedaCare had a prospective contract with each member of the IRC team, which ThedaCare does not bother to allege with any factual specificity. Assuming that, and that there is a causal connection between Ascension's hiring and ThedaCare's alleged harm, Ascension did not intentionally interfere with ThedaCare's at-will employees. Ascension posted job openings available to the general public. One ThedaCare radiology technologist applied. Ascension interviewed her. She was qualified. She was sent an offer. The offer was good, so this technologist spoke with coworkers, and they in turn also applied. This process played out entirely in the ordinary course. Ascension did not actively recruit ThedaCare employees or approach them in a targeted manner in any way. This is a far cry from the organized raid that ThedaCare attempts to paint in its motion. And that's true. ThedaCare accused Ascension of raiding, like RAID, raiding ThedaCare's employees, which is just a total misrepresentation. And maybe there is something here. Maybe there is a retaliation claim or sanctions for misrepresentations on the court. Maybe Ascension gets their attorney's fees back. Maybe these employees can make a Fair Labor Standards retaliation claim for having constructively fired them and then sued their new employer to keep them from working. ThedaCare cannot establish that Ascension acted such that it knew interference was certain or substantially certain to occur. Ascension never even went to the employees directly, individually or together, to induce them to leave ThedaCare. Ascension's actions simply cannot be described as interference under the circumstances. If the law were otherwise, businesses would be required to put competitors' interests ahead of their own. Moreover, even if Ascension's ordinary hiring process for these at-will employees could be deemed interference with a contract, there can be no question that free market, arm's-length hiring in a competitive market is both justified and privileged as a matter of law. Quote, "To determine whether conduct is justified or privileged, the trier of fact must weigh all the circumstances. The factors to be considered include the nature, type, duration, and timing of the conduct, whether the interference is driven by an improper motive or self-interest, and whether the conduct, even though intentional, was fair and reasonable under the circumstances. These factors clearly support Ascension and further confirm that ThedaCare's lone claim lacks merit. Wisconsin has long recognized that competition among market participants is a complete defense to a tortious interference claim. Quote, if the contract involved is one terminable at will, competition is not an improper basis for interference as long as no wrongful means are employed, no restraint of trade occurs, and the purpose of defendant's actions is to advance his or her own competitive interests. Interference with prospective contracts is justified, and a defense to a charge of interfering with prospective contractual relations if it is fair competition and consistent with antitrust law and other principles. One of the most firmly established principles of the common law is that competition is not a tort. That one bears repeating. One of the most firmly established principles of common law, legal precedent, doesn't even need to be a written law. Competition is not a tort. Although competition literally is an intentional interference with competitors' prospective contractual relations, to conclude that it is therefore a tort would be as unsound legally as it would be disastrous economically. The competitor must have both a lawful purpose and a lawful means. The competition justification asks whether the defendant's conduct was reasonable in light of all of the circumstances. Again, there is no evidence of Ascension using wrongful means or acting unreasonably. Public job postings are inherently reasonable. ThedaCare's only alleged evidence of improper interference is that several employees submitted letters of resignation to ThedaCare at the same time en masse. But this evidence has nothing to do with Ascension's actions and provides no support for any of ThedaCare's allegations regarding Ascension's intentions or conduct. The fact that these employees choose to do this simply cannot be imported to Ascension and is circumstantial at best. And as to the at-will employees, they were free to do as they chose. As the Wisconsin Supreme Court put it 100 years ago. But the plaintiff had the right to dispose of his labor wherever he could to the best advantage. This is a legal right entitled to legal protection. Such right could be interfered with by one acting in the exercise of an equal or superior right. As against all others, the plaintiff was entitled to go his way without molestation, and if anyone assumed to meddle in his affairs, he did so at his peril. There is practically little conflict in the cases on this point. At this stage of knowing that the TRO was dismissed and hearing these facts from the opposition, it almost sounds like ThedaCare was interfering with Ascension's contracts or prospective economic relations. I wonder if there will be a counterclaim forthcoming. Thus, not only is ThedaCare unable to show that Ascension acted with a wrongful intentional interference, but even if it did interfere, it was justified competition under the law. ThedaCare has an adequate remedy. In its brief, ThedaCare fails to adequately address this element. In discussing irreparable harm, it merely states that the injuries it will suffer are without any monetary remedy. However, as explained in Ascension's discussion of irreparable harm, ThedaCare has multiple alternatives. It just appears unwilling to pay for them. That kind of financial harm is why we have damages. Courts are not in the business of handing out injunctions to save plaintiffs money. And regardless of the form of relief, Ascension should not be made to pay for ThedaCare's self-caused harm. We call that unclean hands, especially when the remedy is exclusively in ThedaCare's control. Even to the extent ThedaCare loses business to other certified trauma centers, that lost business is compensable with money damages. Also, ThedaCare has offered zero evidence on this point about losing business. The only theoretical harm that could not be remedied with damages would be harm to patients. And despite leading with that point in this court and in the media, ThedaCare has been unable to back it up. And frankly, even if ThedaCare's dire predictions prove true, this would not be harm to ThedaCare, the named plaintiff in this action. In other words, the irreparable harm has to happen to the plaintiff, not to the patients that visit plaintiff. Despite ThedaCare's cries that the Fox Valley community will be irreparably damaged, Ascension is only aware of a Wisconsin court granting injunctive relief solely to rectify harm to the public, and then only rarely when the plaintiff is a public entity and the conduct the plaintiff seeks is to enjoin illegal or contrary public policy action. It refers to a case, the Joint School District Number 1, City of Wisconsin Rapids, authorizing a municipality or public entity to seek an injunction in order to enforce compliance with a county zoning ordinance without a showing of irreparable harm. ThedaCare has presented no authority to the contrary, and ThedaCare is a private entity, and they can't seriously argue that Ascension acted illegally, just as it can't seriously argue that free market competition is contrary to Wisconsin public policy. Absent non-financial harm to ThedaCare, there is no basis for the court to enter an injunction merely to protect ThedaCare's bottom line. A temporary injunction will change the status quo, not preserve it. A temporary injunction will only be granted if it is necessary to preserve the status quo. Fundamentally, the reluctance to disturb the status quo prior to trial on the merits is an expression of judicial humility. Moreover, like the doctrine of stare decisis, or basically case precedent, preserving the status quo serves to protect the settled expectations of the parties. Disrupting the status quo may provide a benefit to one party, but only by depriving the other party of some right he previously enjoyed. ThedaCare admits it learned the first of the departing employees intended to resign their employment with ThedaCare to work for Ascension as early as December 21st, 2021. The resignation of these at-will employees was completely within their rights. The status quo is that these employees now work for Ascension at will, and, far more important, the fundamental right of 7 essential healthcare workers to choose for themselves their place of employment. And that is what's most fundamentally flawed about ThedaCare's lawsuit. These employees have already made their choice, and it wasn't ThedaCare. Nothing that happens in the remainder of the case, regardless of the court's decision on this motion, can force those employees to return to ThedaCare to labor against their will. So the only equitable remedy or fairness remedy available to the court is an injunction prohibiting those employees from serving trauma patients at Ascension. The court may have the power to do that, but the only victims of that decision will be these 7 employees and the unknown number of Fox Valley residents who would have been their patients. That, of course, would accomplish exactly the opposite of what ThedaCare says it wants. In conclusion, the fundamental right of a person to make choices about his or her own employment is well established, and no one has the legal right to deprive a person of the right to labor for whomever he will with the consent of such other. ThedaCare's lawsuit blithely ignores and is fundamentally incompatible with these bedrock principles. And based on the slim record thus far, ThedaCare has been similarly cavalier with the responsibility entrusted to it as a Level 2 trauma center, choosing profit over public health. Now facing the consequences of its own managerial ineptitude, ThedaCare elected to ambush both Ascension and the court with a last-minute filing replete with falsehoods, hoping that the risk of calamity recited in its motion would force a quick resolution before the truth came to light. Even 2 days of weekend inconvenience was enough to uncover how truly baseless this lawsuit is. But blaming someone for your own mistakes is always easier than fixing them yourself. The court should deny ThedaCare's motion. Written by David P. Muth and Brandon Krajewski, I'm Polish, I don't know how to pronounce that, of Quarles and Brady, LLP, I'm assuming of Wisconsin. Yes, of Milwaukee. Bravo! What an amazing opposition brief against that TRO. It hits all the right points. It tells a good story. It attacks in colorful language, in pointed and stabbing motions, legally stabbing motions. And we know now that after reading that brief, hearing the parties' arguments, hearing from the witnesses, from the 5 or 6 or 7 employees, I don't know if all of them testified. Now we know that the judge has vacated the temporary restraining order, dismissed the temporary restraining order, And the only thing remaining to see is what's going to happen with ThedaCare's case, because the case is not dismissed. The case is still alive, and now ThedaCare has to decide if it proceeds with what is clearly a frivolous lawsuit. If ThedaCare does not dismiss the case immediately and potentially settle by paying Ascension for its time and effort, then ThedaCare faces counterclaims and sanctions and whatever else Attorney Muth and Attorney Krajewski can come up with, maybe even a retaliation claim from the employees. Because hear me out here. When you talk about wages or something with your employer, and then they retaliate by terminating you on January 14th, locking you out of your on-call system, changing your job status, and then suing your new employer to prevent you from starting your job. That sounds an awful lot like a Fair Labor Standards Act retaliation claim. So I betcha these employees could sue ThedaCare for retaliation, that Ascension could get sanctions against ThedaCare, potentially sanctions against their attorney for filing such a frivolous lawsuit, could make claims for tortious interference with a contract in the opposite direction against ThedaCare, because they filed a frivolous lawsuit and made misrepresentations to prevent the 7 employees from starting their new jobs. So this sounds an awful lot like one of the stupidest lawsuits I've ever seen. I think this should go right up there in the Hall of Fame of frivolous lawsuits that should have never seen the light of day and clearly had ulterior motives, punishing the employees and punishing Ascension for daring to hire somebody at a competitive wage. Dementia, good name. Thank you for the $10. We only needed a weekend to show how bad this is, and it's that bad. Tim Riggs, thank you for the $5. As Theta and their lawyers had almost all the facts available to them, does their lawsuit potentially rise to bad faith and incur sanctions? Yes, I think so. Lars, $5. Working for the government, I wish I could put a footnote like 4 in the document. Basically, that was just dunking on their counsel. Yes, that they didn't provide any evidence of their speculations. It was this one. To be clear, ThedaCare has offered 0 evidence on the point about losing business. So that was just absolutely epic. And I want to thank you for joining me for that. And I want to thank our supporters for making live streams and Lawful Masses itself possible. You can support us on patreon.com/ljfrench, sponsors.com/law, through Floatplane subscriptions or through YouTube memberships. In January of 2022, thank you to the following $50 plus supporters: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, NotMike, ShadowTycho, Earthbound Star, TechTechPotato, Eric Tams, PureMagma, and the Blood-Soaked Survivors. The rest of the $5 plus supporters will be in the description of the video. I love you all. I'm going to let you go. Have a great afternoon, a great evening. Share this video around because I would love for everyone to see how awesome David Muth and Attorney Krajewski's, what was his first name, Brandon, how awesome their motion was and what a great job that they did for Ascension. That is how you should do legal briefs and how you should conduct yourself as an attorney, not the first one. Also, thank you, Holy Hand Grenade, for the $20. Thank you for your content. Love the follow-up here. Love you guys. Have a good one. Bye.